Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain how to contest a trust in Iowa. A trust contest is when someone challenges the validity of a trust, hoping to get the trust declared void by a court. It's a lawsuit, and if the trust contest is successful, then the court will essentially undo the trust and disperse the funds owned by the trust as if the trust never existed. The grounds for a trust contest are pled in a petition that's filed with the circuit court. So the petition is the thing that initiates the lawsuit, and in order to not be dismissed out of court, you have to state proper grounds that, if true and proven at trial, would be a reason for the court to make the trust considered void. There's several grounds for a trust contest. One is that the trust was not legally and properly executed according to the laws of Iowa. Another is that if it was properly executed, it was executed under duress. This is the proverbial gun to the head, sign this or I'll shoot. But it can be a physical threat or a financial threat or any other sort of threat that forces the creator of the trust to sign the document the way they did. Lack of mental capacity is another ground for a trust contest. When someone executes a trust, they have to be of sound mind, meaning that they understand what they're doing and exactly what's going on while they're executing the trust. Undue influence is another ground for overturning a trust, and that is when someone in a position of trust with respect to the creator of the trust abuses that power that they have and manipulates the creator of the trust into executing the trust in a certain way. Finally, fraud is a reason to overturn a trust, and this can be switching out the document for a different one and tricking the creator of the trust into signing something different from what they think they're signing, or any other deceit, lie, or deception that would cause the creator of the trust to execute the trust in the way that they did. So in order to actually contest a trust, you also have to, in addition to grounds, have standing. So not just anybody, even if there is a reason to contest the trust, not just anybody can successfully file a petition to contest the trust. In order to have standing, you have to stand to benefit from the trust being overturned. So who stands to benefit from a trust being overturned? Basically, anybody who was a beneficiary of a prior trust that would receive more if the trust is overturned. Anyone who is potentially, if there is no prior trust, a beneficiary of a will that would receive the assets of the trust if the trust didn't exist. Or if there's no prior trust or no will, then it's whoever the heirs at law are. Those are the people who stand to inherit according to state intestacy laws if there is no will or trust. So you have to be someone who will actually personally benefit from the trust being held to be invalid. Like I said, you file a petition in the circuit court pleading your grounds for contesting the trust, and then you'll serve a summons on all interested parties. And this, who you need to serve gets a little bit complex, so we're not going to go into it here. But a summons is served by sheriff. You deliver the summons to the sheriff, pay a small fee, and the sheriff will personally serve the summons upon everyone that needs to be served. It can't be just served by mail. If the sheriff is unsuccessful, you can hire a special process server. This is a private investigator that specializes in finding people and serving summons upon them. Once the summons is served upon on all the interested parties, whoever is defending the trust can file an answer to your trust contest, admitting or denying the facts in your petition, and then the case is at issue. At that point, you will both sides will propound discovery upon one another, which means they'll basically ask each other questions, written questions about the arguments that are going to be made at trial and the witnesses that are going to be called, and those written questions have to be answered in writing. They'll also issue requests for production of documents that are held by the other side. So it's basically an exchange of information so that everybody's playing with the same information at trial. After written discovery is done, there will be oral discovery, which is depositions. So anybody that's going to be called as a witness at trial will be interviewed by the other side so you know what they're going to say. And finally, once discovery is complete, there will be a hearing in which both sides will present their evidence, call witnesses. At the conclusion of the hearing, if the person that filed the trust contest met their burden of proving the grounds that they state in their petition, then the trust will be overturned. If not, the trust will stand. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, please feel free to give us a call, 563-503-6910. That's 563-503-6910. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.